So what measure do you believe that the arbitration institutions and the users can adopt to encourage the retention of disputes, because we are the biggest export of the disputes, so, so the retention of disputes in the same jurisdiction, thereby retaining the disputes in the, and maintaining the stability in the legal ecosystem.
Thank you, Eram. Namaste and a very good afternoon to everyone. The common thread, I suppose, which runs through the panel that we are now having is effectiveness and efficiency. And you asked me what measures should be taken by users, arbitration institutions, and the judiciary to maintain that stable ecosystem. So from the standpoint of users, and when I use the expression users, I mean the contracting parties, the first and most crucial aspect is to draft a proper ADR clause, Arbitration Dispute Resolution Clause. Too often, the discussion regarding the dispute resolution clause is left to the end of the negotiation, which is unfortunate. The best practice, however, must be to have clarity about the dispute resolution clause early on. Contracts and commercial relations are unique, and therefore contracting parties should be encouraged and advised to seek expert advice when they are drafting those clauses. Connected to this is the role of the arbitration institutions to provide for model clauses. And when we look at arbitration institutions, if you have some model set of procedures, etc., there can be an excellent starting point for any drafter. As I look at it, Iram, a poorly drafted dispute resolution clause results in a pathological dispute resolution clause, which is as good as having no clause at all. So, from the standpoint of users, as I said, the first important aspect is to have a proper arbitration clause in place. It is therefore important that when they are drafting the clause, it is clear, unambiguous. There must be clarity as to what is the law underlying the contract, law governing the underlying contract. There has to be absolute clarity as to what is the law governing the arbitration agreement, what is the law governing the procedure, where is the seat. These are crucial aspects. The other day I was doing a matter, so we always have this issue with venue, seat, and courts coming up with different judgments. And now I came across a case where the clause says site of arbitration, which was an entirely new thing to me. Was that a typographical error? Did the parties mean venue? Did they mean place? Did they actually mean seat? Wrongly spelled as site? And unless we have clarity about these very basic aspects early on, parties face unique challenges when they have to decide where the challenge will lie, where the enforcement will lie. And therefore, arbitration institutions must come out with a guide to, help parties have a proper arbitration clause. So this was from the standpoint of contracting parties, the users. Now, from the standpoint of arbitration institutions, it gels with my first point that I made, that the procedures that you provide should be simple, efficient, and most importantly, cost-effective. I must commend Justice Gupta, who is sitting here, who is in the midst of formulating the rules for the India International Arbitration Center, and he has been kind enough to ask for comments from practitioners, arbitrators, mediators, so that we can actually put in the best of everything there. There is a big need for administrative and logistical support for virtual hearings, and arbitration institutions must provide for that. Provisions for arbitrators to provide for virtual hearings, depending on the needs of the matter, and also in-person hearings. Transparency in administrative processes, that's another very key aspect. Cost sanctions, if there are delays in conducting arbitration proceedings. Then provision for a secure electronic filing and document sharing platforms, and that's a remark my friend Tejas also made in the previous session. That's the need of the hour. And lastly, from the standpoint of the judiciary, I must mention and commend that so far as judiciary and the executive is concerned, I think on their part they are trying to ensure that there is a stable legal ecosystem. The judiciary ensures that the interference with awards at the challenge stage is minimal, and that's very important. There is also a growing wish that the seats that the parties choose must have the judicial capacity to implement technological advances, which in turn goes back to your first remark, efficiency and effectiveness. So for example, a local court which has the wherewithal and the ability to deal remotely with an arbitration mandate or a matter. So I would advise, encourage my clients to choose a seat where those technological advances are present. Executive on its part is also trying to do all possible. I must invite your attention to this office memorandum which came in 2016, Committee of Economic Affairs, where ministries were encouraged to follow awards and make 75% of the amounts to all concessionaires, contractors, to ensure that there is cash flow. And all these things put together, I believe, will give some assurance to the users who are at the heart of this ecosystem that yes, if they're opting for arbitration, they'll get the fruits of their hard-earned process, and it will not get stuck unnecessarily in prolonged litigations. I hope that covers.
It covers more than what I asked, Sidharth. So thank you so much for this answer. And, it gives me, food for thought. Yes, when everybody talks about efficiency, they never thought about that, how to improve, include technology into it. And let me tell you that my recent experience, and I was in the New York UNCITRAL Working Group 2, I represented APCAM, and there was a discussion on the model clause. They are trying hard to find a model clause where the entire dispute related to technology should be resolved within 1 month. And the CMC time will be 10 days only. So what do you think, Sidharth? So we'll start from you only. So how, we say that the arbitrator to ensure the cost effectiveness of the procedure, and what strategy can they employ to develop a personalized fee schedule that align with the specific need and resources. So this is the question which I would like to know from all of you, your perspective, that how to make arbitration cost effective.
So as far back as in 2009, our Indian Supreme Court in this judgment, Union of India versus Singh Builders Syndicate, had flagged the issue of indiscriminately high arbitrators' fees. And the Lordship said that it's a major challenge to the growth of arbitration in our country. They went on to state that contrary to the legislative intent, the arbitration proceedings are disproportionately expensive, and those are the expressions used in that judgment, which then led to the 246th Law Commission report. And the Law Commission recommended a fee schedule, a model fee schedule to be incorporated, which was then of course done in the 2015 amendment. Certain changes, amendments made in 2019, some of them have to be notified, but to streamline the process. Now the confusion surrounding the fourth schedule which we have in our Arbitration Act has now been settled by the Supreme Court in ONGC versus AFCONS, and they say fourth schedule is not mandatory, and parties can, in their wisdom, agree to a more customized fee schedule. So to take it from there, I would say that the parties should be encouraged to opt for that, to have a more customized fee schedule, and they can provide for various things. Adding an additional fee to the fee schedule if the arbitration proceeding is, let's say, concluded within 6 months. Setting goalposts. This will, in fact, encourage the arbitrators to conclude the proceedings in a time-bound manner. And this is also, in fact, envisaged in our statute, in the Arbitration Act. I believe Section 29(2) provides for that. That if you finish it within 6 months, you'll get an incentive.
You will get bounty.
Yes, yes. So then the other way to make them cost effective is that you need to agree to a cap on the maximum number of procedural hearings that you can have and the number of substantive hearings you can have. We've seen arbitrations which go on and on and on. So there has to be a cap to that, and parties in their customized fee schedule and agreement prior to the commencement at the case management hearing stage can agree to something like that, and it benefits everyone. Then with the arbitrators also, I would say that there has to be a clear understanding as to what the fee is going to be. There have been instances and cases where towards the end of the proceeding there is confusion as to what fee was agreed, what was not agreed, and mind it, under the Act, the tribunals have a lien on the award under Section 31 for the costs, right? There can also be an agreement in the case management hearing that minor procedural hearings which only involve housekeeping issues should be done virtually. There is no need to have an in-person hearing for that, because you end up saving so much costs there, travel costs, staying costs, costs of hiring a venue, etc. Many a times we have to bring senior counsels from other jurisdictions. In international arbitrations, more so. So that's something which can be done. So I think a couple of these things, if taken in mind, can reduce the cost and make the arbitrations cost effective. Yes. In ad hoc arbitrations, of course, there's one additional aspect that you can always request the tribunals, and most tribunals are, they do not take it otherwise, at least so far as my experience goes. If in matters which do not involve that complex a dispute, there may not be a need of any secretarial assistance. So the charges which are otherwise, the fee that you pay to secretaries, etc., that can be taken care of. Then the reading fee is something most tribunals are more than happy to, reduce if you request them, that this does not involve that complex a matter. So those are things if there's understanding between counsels and you have a tribunal at case management hearings, these things can be ironed out.
Sidharth, would you like to add?
If I could just add one bit to it. So we are looking only at enforcement, but when we talk of users, we should also look at the challenge.
Yeah.
And those are also issues which arise, especially in cases where you have those poorly drafted clauses. Again, it goes back to the same issue, and therefore I say that's something which needs to be done early on in the negotiations and not left to the end.
When the party in the happy terms.
Yeah, and this is more prominent a problem when we are looking at agreements prior to the Balco regime.
Yeah.
After the Balco regime came in, after 2012, you still have clarity about seats. If you have provided a seat in the arbitration clause, what is the legal consequence of that, where the challenge will lie, etc. All those things are still streamlined. But when you look at the pre-Balco regime and those agreements, and many of them are in existence, several of them getting into disputes, which provide venue of arbitration will be at a certain place. And parties in their wisdom chose, let's say, a foreign venue, and they decided to be governed by a foreign set of rules, let's say ICC rules. There is still not much clarity as to when the award is passed in that matter.
Yeah.
Where will the challenge lie? Will an Indian court entertain the challenge? There are certain judgments which have come up with this rationale that if you add something to the venue, it becomes seat. But pre-Balco, I must say, was all the Bhatia principle, the venture grower principle.
Yeah.
Are you then trying to look at those cases, the Bhatia and venture global cases, with the lens of Balco regime? In my view, you can't do that. Because in Bhatia and venture, the clauses provided venue of arbitration will be a foreign jurisdiction, and there were foreign rules. But there are certain judgments which now say that if you add a supranational body of rules to venue, it becomes seat. That's true for post-Balco, not pre-Balco.
Yeah.
So that's an interesting issue we keep facing in all agreements prior to 2012.
Yeah, thank you so much, Sidharth. So it's been a very nice discussion and look like a small capacity building, training program is happening just on the user's perspective. So yes, Sidharth.
I think my fellow members have covered most of these aspects, but speaking of best practices, I believe step dispute resolution clauses should also be provided for in the procedural rules. Many parties may want to try for mediation or negotiation before they actually get into the arbitration mode, and this is more so in cases where the commercial relationship is long-standing and ongoing. So those best practices which are prevalent in some of the other rules, when we are formulating rules, when looking at custom-made procedures, that's something which should be addressed. And for complex and multi-party disputes, tailor-made procedures, that's also another area which is important. You asked about initiatives which should be taken. And I'm sure this initiative which APCAM has taken, conducting workshops and seminars, because best practices you learn through dialogue, through arbitration weeks, through congresses, through workshops. So having more of workshops and seminars where there is information being shared, I would say there needs to be an ad hoc institution under the control of the government so that there's information symmetry in relation to international arbitrations and the procedures, etc. Arbitration institutions should tie up with colleges and encourage budding lawyers, teach them best practices so that they get trained at that stage itself and they know what should be done, what should not be done.
Students are listening you and very happy.
So that's another aspect which I believe should be addressed and done.
It should be more.
So I believe those are the things Iram should...
Yeah, so...